Thank you, Caroline. I just want to begin by acknowledging the considerable amount of work that was carried out by Senator McDowell and the independent senators and Deputy O'Callaghan in rectifying what is a patently unjust situation arising out of the interpretation of the court and by the court. And I want to acknowledge and thank Minister that you haven't stood on ceremony, that your own sense of urgency in rectifying this situation for families who have experienced great hurt as a consequence of it. Albeit that there was no other conclusion that could have been arrived at by the judges deliberating on this matter. I think that in doing their job, in carrying out such a strict and literal interpretation, you know, we unfortunately arrived at a situation where we could have justice not being seen to be done as a consequence for victims where they were child victims, and it is absolutely urgent that we address that. The Children's Act, that section of the Act, was clearly about protecting that children should not be forever identified with the crime perpetuated against them or being witnesses to a crime that was perpetuated. And in so doing, I'm confident that the view of the legislators was in child protection, and it is important that as we deliberate on this, we continue with that mindset that it is about child protection at all times. So in addressing what is a very narrow particular of circumstances and interpretation, it's important that we don't have a lot of consequences that flow from that again are unintended consequences. So where the child has died, in that we have the controversy. The living child was not there's nothing controversial about that. Nobody would attest to that. They would understand that a child has a life to live and deservedly of their anonymity. But we need to allow the identity of children to be published that are deceased in the most unspeakable of crimes. It is the right of parents and families to speak of their child and to remember all that was lovely about their child. I think we could have arrived at a situation where victim impact statements by families could not have been produced in the media, that the statements on the steps of the court following the conclusion of a trial, that families wouldn't get to bring to life all that is good and all that is lovely and all that is to be remembered about their loved one, keeping them. It's part of their mourning, part of their memorialisation, part of their keeping their child's memory alive. I think our adversarial system, our judicial system, albeit correct, and I would stand over it, having been in it many a time on both sides for prosecution and defence, but we do see that at times we can end up with a defence narrative that may be afterwards accused to be exaggerated or one-sided, that we've seen sordid details of the deceased come out as the narrative builds on behalf of the defendants, and it is very important that we have a right of reply. It is very important that the record is put straight. So I suppose in the tenderness and the humanity of the deceased needs to be brought out following that, and the follow-up programmes following the conclusion of a trial, where the media have a role in this, in making sure that the story of the victim, and we've seen this over the last number of years, and in particular notorious cases. So parents have the right to reclaim the identity of their child following the conclusion of a trial, and to be able to speak freely about that. But also in this, it is really important that adults who were victims of crimes as children get the opportunity to have the right to waive the anonymity. And I think in the government's proposed amendments we will see that also, that though they were children at the material time of the offence being perpetrated against them, that now, so in cases of historical sexual abuse, in instances like that, it is important that now we have an opportunity, that they're entitled to waive that anonymity. And I suppose we see through a different different lens when we go back to read the section. I would have read the section, you know, previously and seen nothing wrong with it. Then the case comes through, and now you see it very differently. And what I do see in the section now is that all of the power sits with the court, whereas I think the victims should have a say in whether they have a right to lift that anonymity or not. It is about the court. So it is important that the locus there of the right to waive stays with the victim, although they're now an informed, presumably, and advised, well-advised adult. That is important that we do that. And I for one would very much support that child perpetrators are protected, that their anonymity is always protected, and that there isn't any unintended consequences arising out of this legislation that affects that. They do have, if we're going to have a restorative justice model and rehabilitation and all of that, then that is important that they get to start again. So in conclusion, just thank you for your approach to this, Minister. I think it has been great. Thank you for all the hard work and for the instant. We could have had to wait for the Supreme Court and for it to be struck down and for all of that, but thankfully we didn't, and so that we had it ready to go is really a fine part of our legislature. It is one to be proud of. So thank you.